Okay, we're live.
All right, you. Hello, good afternoon, good evening, good morning, depending where you are. Welcome to today's webinar, Understanding the World Course Climate Change Advisory Opinion. I'm Sean Mu. I'm a professor of energy economics and also the director of the Center for Energy, Petroleum and Mineral Law and Policy, CEPMLP, at the University of Dundee. So the webinar is in collaboration with the International Society of Energy Transition Studies, which is headed by alumni, Dr. Shi Xunpeng, and CEPMLP 500, and the Nigeria chapter of the University of Dundee Alumni Association, and of course, Dentons, which provided today's Zoom, the infrastructure support. So this is the second in the series of webinars we organized together with our wonderful alumni groups. So the topic today is about the International Court of Justice advisory opinion. The reason we have this webinar is that almost 2 months ago, the International Court of Justice issued an advisory opinion on state obligations in respect of climate change. Forgive me, I'm not a lawyer, but I heard this is important. People use the words like landmark decisions, and it will influence the court, international courts, the judges, or whatever the behaviors. How important it is, this is, I think we can try to find out in today's webinar. So joining me today are two of my distinguished colleagues, Professor Peter Bekker and Dr. Ernesto Bonafe. Peter is a professor and chair of international law at the Center at the CEPMLP and also a partner at Dentons in New York. He is joining us from the Dentons New York office. And his research and teaching concentrates in public international law and international dispute resolution involving private and sovereign parties. He served as a staff lawyer at the International Court of Justice in the 1990s, and he is an active member of the New York Bar, and he serves as a counsel and advocate in cases before the ICJ. So you can see no one is better to talk about the ICJ decisions or advisory opinions than Peter is. He has written 2 books and more than 100 articles. There's Professor Peter Bekker. We also have Dr. Ernesto Bonafe joined as a discussant. Ernesto formally joined the center about 2 years ago, I believe, as a senior lecturer, and he teaches energy transition and climate change. And before he joined the center, he worked at a number of international organizations, including the Secretariat of the International Energy Charter Treaty. So the format of today's webinar is that Peter will speak about 25 minutes, and Ernesto will then join as a discussant to speak maybe 5 to 10 minutes, then we'll open questions. So if you have any questions, please type in the Q&A sessions, the box. I think we will leave plenty of questions at the end. Without much further ado, I leave the floor to Peter.
Thank you, Sean. My pleasure to address you in this webinar from New York. The goal of the webinar is to help you understand what the World Court ruled in its climate change opinion. The opinion of 23rd of July of 2025 was highly anticipated, following advisory opinions on climate change related questions issued by the International Tribunal for the Law of the Sea, ITLOS, in May 2024, and the Inter-American Court of Human Rights in May of 2025. And these are referenced in paras 123 and 385 of the advisory opinion. Now, what is remarkable is that it took the court only 27 months to deliver its 132-page answer to the questions posed by the General Assembly of the United Nations. By comparison, maritime boundary disputes between sovereign states have taken 65 months on average to be adjudicated by the World Court. The climate change advisory proceeding was the first time that many states and climate vulnerable countries, including small island developing states or SIDS, especially the Pacific Island states, had their voices heard before the principal judicial organ of the United Nations. Some 100 countries and nearly a dozen international organizations participated actively in the proceedings before the court. And this broad participation and broad agreement on many points in the submissions before the court undoubtedly helped shape the court's finding. So what was the outcome? Well, in a nutshell, the World Court's advisory opinion did not resolve every issue and every controversy regarding climate change, but it provided clarity where clarity was needed most, namely that climate change is not only a political challenge and a policy matter, but it is a matter of law. And then in this context, I would like to mention the following statements made by the court throughout its opinion. The court referred to, quote, the urgent and existential threat posed by climate change, unquote, in paragraph 73. It said climate change is a global problem, in paragraph 115. It also said climate change poses a quintessentially universal risk to all states, in paragraph 137. And it said climate change is a common concern of mankind, in paragraph 364. The advisory opinion unquestionably is a landmark ruling, but it is more limited than some have claimed it to be in its aftermath. The advisory opinion does not reshape global climate law. It does not mention climate justice. It mentions the energy transition only once, namely in paragraph 85. We must keep in mind, as Judge Peter Tomka, who's the court's senior judge and a former ICJ president, noted in paragraph 4 of his individual declaration that is attached to the advisory opinion, that, quote, the role of the court, all the more so in the context of an advisory opinion, is to clarify the law, not to anticipate the law before the legislator has laid it down, end quote. So what is the legal status of this ruling? Now, while the World Court's advisory opinions are non-binding under the court's statute, this non-binding character does not mean that advisory opinions are without legal effect, because the legal reasoning embodied in them reflects the court's authoritative views on important issues of international law. And in arriving at them, the court follows essentially the same rules and procedures that govern its binding judgments delivered in contentious cases submitted to it by sovereign states. An advisory opinion derives its status and authority from the fact that it is the official pronouncement of the principal judicial organ of the United Nations. Unanimous rulings, as in this case, make this kind of official pronouncement even more authoritative. However, in his individual declaration, Judge Tomka stated, quote, oracular pronouncements may, by virtue of their conciseness, have helped the court reach a unanimous opinion, but it comes at a cost, end quote. And he criticized his colleagues for having gone beyond the established law on certain points. The climate change advisory opinion was adopted unanimously by 14 judges, not the regular 15 judges. Why only 14? Well, ICJ President Nawaf Salam had resigned in January of this year to become Prime Minister of Lebanon, and his successor had not yet taken his place on the bench. Now, I referenced Judge Tomka's declaration. Individual declarations and separate opinions help to understand the World Court's ruling. The declaration by U.S. Judge Sarah Cleveland, a Biden appointee and human rights scholar, is especially interesting. She also appended 2 joint declarations, one with the judge from India, focusing on fossil fuels and the energy transition, and another with the judges from Australia, Brazil, and Romania. The only way to properly understand a World Court ruling is to read both the text of the ruling and that of any individual declarations and separate and dissenting opinions attached to it. There are 12 attached to this ruling. Now, a word about the science factor. One of the key takeaway points from the July ruling is the World Court's endorsement of the scientific reports issued by the Intergovernmental Panel on Climate Change, IPCC, which was created in 1988 and comprises 195 member countries. That's 2 more than the United Nations membership. According to the ICJ, and I quote, "It will rely primarily on the IPCC reports, which participants agree constitute the best available science on the causes, nature, and consequences of climate change." This is in para 74. Science undergirds the ruling. According to the ICJ, quote, "It is scientifically established that the climate system has undergone widespread and rapid changes, including in particular an increase in global surface temperatures or global warming. Climate change is caused by the accumulation of certain gases in the atmosphere that trap the sun's radiation around the Earth, leading to a greenhouse warming effect. While certain GHGs occur naturally, it is scientifically established that the increase in concentration of greenhouse gases in the atmosphere, and here it comes, is primarily due to human activities, whether as a result of greenhouse gas emissions, including by burning of fossil fuels, or as a result of the weakening or destruction of carbon reservoirs and sinks such as forests and the ocean, which store or remove greenhouse gases from the atmosphere." End quote. This is in paragraph 72. Climate change deniers take note. So what are the main findings by the court? The court was asked by the General Assembly of the United Nations, comprising 193 member states, to opine on both the primary climate change obligations of states and the legal consequences of states flowing from those obligations. According to the court, the most directly relevant treaty instruments in this space are the 1992 United Nations Framework Convention on Climate Change, the 1997 Kyoto Protocol, and the 2015 Paris Agreement, which was adopted by the 21st Conference of the Parties to the UN Framework Convention and has 195 parties. Now note that US President Trump announced the US withdrawal from the Paris Agreement immediately after his inauguration in January of this year. The court offered a detailed analysis of the legal obligations of states under each of these 3 treaties, which in and of itself is most helpful. Most importantly, however, the court went beyond the core climate change treaties, and it opined that the whole corpus of international law is applicable law in the climate change context. And Article 38 of the ICJ statute lists treaties, customary international law, and general principles of law as the 3 formal sources of international law. All 3 are relevant. The court sent a clear message that treaties must be read as part of an interlinked system of law, and the climate change treaties cannot be viewed in isolation. They must be read in the context of the UN Convention on the Law of the Sea, other environmental treaties such as the Ozone Layer Treaty, and customary international law and general principles of law. The court flatly rejected the argument advanced by some states, mostly Western states, that only the UN Framework Convention on Climate Change and the Paris Agreement establish climate change obligations, and that nationally determined contributions, or NDCs, under the Paris Agreement are not enforceable or justiciable. In the court's view, and I quote, "Rather than being entirely discretionary, as some participants argued, NDCs must satisfy certain standards under the Paris Agreement," end quote. This is in para 249. Now, it must be kept in mind that the advisory opinion addresses the obligations of states, not of private operators, in the context of climate change, particularly climate change due to anthropogenic greenhouse gases, or GHGs. The ICJ found unanimously that a state can be in breach of its obligation to take measures to mitigate greenhouse gas emissions, thereby engaging its responsibility under international law. And perhaps the key finding in the ICJ's ruling is found in paragraph 409, where the court stated as follows, quote, a state that does not exercise due diligence in the performance of its primary obligation to prevent significant harm to the environment, including to the climate system, commits an internationally wrongful act entailing its responsibility, end quote. Another key finding was the court's statement that the customary duty to cooperate is, quote, not a matter of choice for states, but a legal obligation, end quote. That's in para 364. The court considered that international cooperation is indispensable in the field of climate change. That's in para 215. And that the duty to cooperate is an obligation of conduct, the fulfillment of which is assessed against the standard of due diligence, para 218. In other words, there is no place for isolationism here. The court did note that, quote, states are free to select the means of cooperating, as long as such means are consistent with the obligations of good faith and due diligence, end quote. The court mentioned financial assistance, technology transfers, and capacity building, referred to in the Paris Agreement, as the principal forms of cooperation, interstate cooperation. In the court's view, quote, the duty to cooperate requires sustained and continuous forms of cooperation. And while states are not required to conclude treaties, they are required to make good faith efforts to arrive at appropriate forms of collective action. This is in para 304. In 305, the court said the duty to cooperate is applicable to all states. Moreover, the court observed that, quote, the most significant primary obligation in relation to climate change is the obligation to prevent significant harm to the climate system and other parts of the environment, which applies to all states, including, here comes, those that are not parties to one or more of the climate change treaties, end quote. It's para 409, hint, United States. The court observes that, quote, the notion of due diligence is the relevant standard for determining compliance with these obligations. Due diligence requires a state to use all the means at its disposal to prevent significant harm to the environment. This is set forth in para 281. The ICJ reaffirmed the need for states to take all necessary measures and to do, quote, their utmost, end quote, to prevent climate change harm, guided by the best available evidence. Always keeping in mind the principle of common but differentiated responsibilities and respective capabilities. And this is set out in paras 148 through 151. Now, most importantly, the court considered that all states have a common interest in the protection of global environmental commons, like the atmosphere and the high seas, and the obligation to prevent significant transboundary harm under customary international law is an obligation erga omnes. That is, it is an obligation of international law from which no state may derogate. Very powerful. Paragraph 440. So a word about human rights. The ICJ confirmed that international human rights law forms part of the corpus of international law that is relevant to climate change issues. And the ruling discusses several human rights as they apply to climate change. This part of the ruling may prove particularly instructive for climate change litigation before national courts, as Sean referenced. According to Columbia University's Sabin Center for Climate Change Law, which tracks global climate-related lawsuits, there are already more than 3,000 such lawsuits working their way through national courts around the world. The courts hearing those arguments are likely to look to the ICJ advisory opinion in making their own binding decisions in a national setting. So what about private actors? So in the court's view, quote, states must take measures to protect the climate system and other parts of the environment, and these measures include the regulation of activities of private actors, end quote. 403 is the paragraph. According to the court, quote, rules and measures must regulate the conduct of public and private operators within the state's jurisdiction or control, and they must be accompanied by effective enforcement and monitoring mechanisms to ensure their implementation, end quote. Para 282. Very clear message. Therefore, it is not an option not to regulate to protect the climate system. Now, on the second question that the General Assembly of the UN posed to the court, namely about legal consequences flowing from the obligations, or what we call secondary rules of state responsibility, the court made the following remarkable statement. Quote, failure of a state to take appropriate action to protect the climate system from greenhouse gas emissions, including through fossil fuel production, fossil fuel consumption, the granting of fossil fuel exploration licenses, or the provision of fossil fuel subsidies, may constitute an internationally wrongful act, which is attributable to that state, end quote. That's paragraph 427. May prove to be controversial, but very powerful. Incidentally, the court refers to fossil fuels only a dozen times in its 132-page ruling, and it does so mostly by invoking reports that have been issued by the IPCC panel over the years. The court also mentioned the conduct of private actors in paragraph 428, where it noted that, quote, a state may be responsible where, for example, it has failed to exercise due diligence by not taking the necessary regulatory and legislative measures to limit the quantity of emissions caused by private actors under its jurisdiction, end quote. That's para 428. Now, contrast the ICJ's endorsement of objective science with the US administration's recent announcement that it will repeal limits on greenhouse gas emissions that stem from burning fossil fuels. On the 2nd of September, the New York Times reported that, quote, more than 85 American and international scientists have condemned a Trump administration report that calls the threat of climate change overblown, saying the analysis is riddled with errors, misrepresentation, and cherry-picked data to fit the president's political agenda, end quote. And this past weekend, the New York Times reported that the US Environmental Protection Agency will stop collecting emissions data from thousands of coal-burning power plants and other industrial facilities in the United States. And this data is the country's most comprehensive way to track greenhouse gases. Now, note that the ruling nowhere mentions that there is an obligation to reduce global reliance on fossil fuels. The joint declaration of Judges Bhandari of India and Cleveland of the United States draws attention to the fact that the ruling does not do so, and they chide it for the omission. The court's omission must have been purposeful. Thus, states before and after the ruling have a free choice of means how to reduce net emissions and the accumulation of greenhouse gases in the atmosphere, and how to meet the warming goal of 1.5 degrees Celsius. But not doing so, not doing anything to combat climate change, is not an option. That is what this advisory opinion makes clear. Now, about the law of the sea. The opinion devotes nearly 8 pages to the law of the sea and climate change. The oceans cover some 70% of the Earth's surface area. And the Arbitral Tribunal in a case between Bangladesh and India observed as follows in its 2014 award. This is paragraph 217, and I quote, neither the prospect of climate change nor its possible effects can jeopardize the large number of settled maritime boundaries throughout the world, end quote. This means that only settled maritime boundaries are immune to sea level rise due to climate change. Boundaries that remain to be delimited are not, yet just under 50% of all maritime boundaries in the world remain to be delimited. It's 60% of undelimited boundaries around the African continent. As the BBC reported over the weekend in an online story by Lana Lam, quote, rising seas threaten 1.5 million Australians by 2050, end quote. That's just Australia. Imagine the threats faced by small island development states, especially Pacific Island states such as the Solomon Islands, the Marshall Islands, Vanuatu, and Palau. And they were behind the General Assembly requesting this advisory opinion. The ICJ confirmed the International Tribunal for the Law of the Sea's May 2024 opinion that greenhouse gas emissions may be characterized as pollution of the marine environment, an important endorsement in paragraph 340. The ICJ observed that the obligation under UNCLOS Article 192 to protect and preserve the marine environment consists of a positive obligation to take measures to protect and preserve the marine environment, and a negative obligation not to degrade it, again by reference to the ITLOS advisory opinion of 2024. This is paragraph 342. And in this context, the ICJ stated that the standard of due diligence to be applied is stringent, high standard. States must implement legislative measures, administrative procedures, and enforcement mechanisms necessary to regulate activities polluting the marine environment. They must act. So this advisory opinion is issued at an interesting time because the BBNJ agreement, which is a recent multilateral treaty addressing biodiversity in areas beyond national jurisdiction, beyond 200 nautical miles, is anticipated to enter into force in early 2026. And the preparatory commission under the BBNJ agreement is currently working on developing its institutional mechanics and details. The oceans are crucial to moderating the effects of greenhouse gas emissions, and the BBNJ agreement is essential for conservation of the 2/3 of the marine environment that lie outside the control of any one state. The court's treatment of sea level rise was especially interesting, particularly for small island developing states facing an existential threat from rising seas due to climate change. The court stated that baselines along the coast, which are the starting point for measuring maritime entitlement, once established remain fixed, and that territory lost to the sea does not automatically mean loss of statehood. Now, the senior judge's declaration, Judge Tomka, says that he actually took this issue as the one issue that he criticized because in his view, the ruling goes beyond existing law on the issue of when statehood arises and may be lost. But again, it's good news for those vulnerable states in terms of what the court said. Now, another contribution that stands out is the court's treatment of treaties as living instruments. So not fixed, they're living. The ICJ opined that decisions adopted by the Conference of the Parties, or the COP, are relevant to treaty interpretation. And that statement will keep treaties like the BBNJ agreement alive and adaptable. COP decisions adopted under the BBNJ agreement can be expected to influence customary international law, and customary law will in turn shape how treaties such as the BBNJ agreement are understood. Now, finally, a quick word about things that were not addressed in the ruling. The International Union for Conservation of Nature, IUCN, hosted a webinar on 22nd of August, and that was styled the ICJ Climate Change Advisory Opinion, a turning point for climate justice from the World Court. There was no question mark in the title of that webinar. However, the advisory opinion does not mention climate justice or just transition anywhere, which may disappoint climate activists and just transition scholars. The ICJ does not refer to the term energy transition as such, but it states in paragraph 85, quote, mitigation includes both reducing greenhouse gas emissions through measures such as transitioning away from fossil fuels and improving energy efficiency, end quote. But that is all. The ruling is silent on specially affected states and cumulative impacts of climate change. The ICJ stated explicitly that, quote, the application of the rules on state responsibility under customary international law does not differ depending on the category or status of an injured state, end quote. Paragraph 109. In other words, there is no special protective regime for small island developing states under international law. The ruling also leaves uncertain when exactly the obligation to act to combat climate change due to greenhouse gases began. Was it in 1992 when the UN Framework Convention was concluded, or was it earlier? The timeline is complicated by attribution science, an issue from which the ICJ steered clear. In the context of monetary compensation for climate change breaches, which it recognized and that are attributable to a state, the court observed, and I quote, in the climate change context, reparations in the form of compensation may be difficult to calculate, as there is usually a degree of uncertainty with respect to the exact extent of the damage caused, end quote. This is in paragraph 454. The court did note that in uncertain cases, compensation in the form of a global sum may be awarded by an international court of tribunal, but only on an exceptional basis. So to wrap this up, in sum, the advisory opinion, while helpful in clarifying global climate law, is a bit of a mixed bag, as I have just outlined. Over to my colleague, Dr. Ernesto Bonafe, for his comments. Ernesto?
Thank you very much, Peter. So in my comment, I would like to refer to the role of the International Court of Justice, which has the obligation to clarify the law. With regard to the governance system, the Paris Agreement is the global response to the threat of climate change. Then what's the relevance of this advisory opinion for the energy transition? Peter Bekker said that the references to the energy transition are basically non-existent in the advisory opinion, are not a central part, for sure. And third, I would like to refer to the role of the advisory opinion as a legal reference that can be used by courts and tribunals across the world. So first of all, regarding the governance system of climate change, this is a system set up by governments, by sovereign countries who remain the masters of the process. And the best example of it is that any country can withdraw from the Paris Agreement. It has been the case 2 times by the United States. Not only that, the United States, with its trade and tariff policy, is allegedly putting pressure on some countries to undermine their climate obligations. So not only the US has quitted the Paris Agreement, but some criticize its trade policy because it's about baby drill in the US, but also for countries across the world to buy their fossil fuels, which is not in line with the climate obligations. There are other examples. The European Union is taking longer than expected to define its climate ambition for the year 2040 in a new legislation to be passed in the European Union, or its NDC to be submitted to the COP30. So there is no unanimity or not clarity, consensus among EU member states to define what is the level of ambition within the European Union to be adopted and to send a message to the rest of the world. You know that the European Union likes to present itself as a global climate leader. So we can see now some hesitations or some limits in this role of the global climate leader. And so Peter Bekker also mentioned the legal obligation of cooperation, including financial assistance. This is an obligation of conduct, but not an obligation of result. So how this advisory opinion can help developed countries to honor their obligations and commitments to assist financially to developing countries through climate finance obligations and mechanisms. So the whole governance, global governance system of climate change has some limitations because countries are the owners of the process. They are sovereign states. And of course, this is a limitation for the International Court of Justice, something to be considered. Then on point two, regarding the energy transition, it's not surprising that the energy transition is not a central part of the advisory opinion, even if it's at the center of the global just transition. It's not possible to achieve the Paris goals or the climate reduction, the emission reduction objectives without a complete transformation of the energy sector, without the decarbonization of the energy sector. So why the International Court of Justice is not mentioning or is not tackling as a core issue the energy transition? I think it's not surprising because it took more than 30 years for the United Nations system of climate change, since the adoption of the United Nations Convention, Framework Convention on Climate Change in 92, then Paris Agreement 15, and then COP28, I think, in Dubai, when for the first time, with adoption of the global stocktake, was put on paper that the fight against climate change was about transitioning away from fossil fuels. But even for a lawyer, this was not very satisfactory because it followed the line saying that in a just, equitable, and fair manner. So what does it mean? Everyone was happy with this drafting. Countries who were more ambitious or less ambitious, they were all happy with this ambiguous formulation about the energy transition, consisting of transitioning away from fossil fuels. So it took 35 years to agree on a very ambiguous and general sentence that then was put aside in the following COPs. In last year was not mentioning to the transitioning away from fossil fuels. So if governments, states do not agree on how to conduct this global energy transition, we cannot expect the Court of Justice to do the role or to do the work that is to be done by countries. So what are the merits of this advisory opinion? In my view, it will be a very important legal references for judicial cases to be decided at national level. Peter Bekker mentioned that more than 3,000 cases related to climate litigation, as counted by the Colombian Climate Change Institute, are taking place all across the world. So now these cases and future cases can benefit from the legal authority of the International Court of Justice. What the International Court of Justice has said this summer is not completely new, and I would like to refer to some legal innovations at judicial level that have been taking place for the past couple of years, particularly in the United Kingdom and also in the Netherlands, and then in Norway, which is not surprising because in these countries, they have been confronted to both things, to the production of the possibility to keep extracting fossil fuels, and at the same time, a commitment to fight climate change. So this tension has translated into legal conflicts that have been decided by courts in the UK, in the Netherlands, and Norway. And in that sense, I would say that these courts, national courts, were faster and farther than the International Court of Justice. The advantage of the International Court of Justice is that these legal innovations now can be spread across the world, not under the authority of the UK Supreme Court or the authority of the Dutch Court of Appeal, but under the authority of the International Court of Justice, which can be more comfortable for jurisdictions across the world. Also because there was not unanimity within the Supreme Court, for instance, when dealing with the Finch case that was decided in 24. So Finch was a local resident in Surrey, in England, who opposed the planning permission for the development of oil extraction in his area, in his local area. It challenged the decision of the city council to give planning permission on the basis that the environmental impact assessment did not consider scope 3 emissions. So the city council, together with the developer, said that the emissions should be considered within the boundaries of the oil sites and not indirect effects of this production that happens when downstream the oil extracted there will be burned somewhere else. So that was decided by the Supreme Court, saying that scope 3 emissions have to be considered when granting a planning permission to go ahead with a fossil fuel project. The consequence of that was that immediately some major oil and gas projects, Rosebank and Jackdaw in the North Sea, were suspended because the approval did not consider scope 3 emissions. Then the EFTA court in Norway, so for Nordic countries outside the European Union, reached a similar conclusion than the UK Supreme Court. So we can see some innovation by two national Supreme Courts, or by the UK Supreme Court and the EFTA, a free trade agreement for the Norway, Iceland countries, that has been endorsed by the International Court of Justice in its advisory opinion of this summer, saying that without mentioning this case law, the International Court of Justice says that downstream emissions can be considered in the environmental impact assessment. So that's why I was saying before that now national courts across the world can refer to the International Court of Justice to impose the assessment of scope 3 emissions when authorizing fossil fuel projects. But there's also limitations for this, because the Supreme Court said it doesn't mean that the project cannot go ahead. It only means that scope 3 emissions have to be considered. Some months later, or it was in June, or 1 year later, the UK government said, okay, now we have new guidance how to make the environmental impact assessment for fossil fuel projects, but the Secretary of State for Energy will take into account the environmental impact assessment, certainly, but also other economic impacts or implications of the project. So we can see that even if there is an obligation to take into account emissions, scope 3 emissions, this has been amplified, extended by the International Court of Justice, but the solution adopted by the UK government will be adopted also by other countries, saying the last word is for the government. Then if again, still in the United Kingdom, the United Kingdom adopted the Climate Change Act, the first one in the world, 2008, modified in 2019. And on that basis, the Secretary of State has to adopt a carbon budget. Carbon budget 6 was the most ambitious. It covers 5 years period in the next decade, because it included also the emission reduction in aviation and shipping. So some NGOs consider that the carbon budget adopted by the Secretary of State was not ambitious enough to achieve the legal obligation to reach net zero by 2050. So they went to court, and the court in 22, High Court in England, said that these NGOs were right, that there was not enough clarity on how the UK government would achieve its legal commitment to reach net zero. Then the UK government worked on a new plan, a new carbon budget to deliver this objective. And again, it ended up in court with the same outcome. So the court saying that the government is not aligned with the legal obligations to reach net zero. So we can see that how the level of scrutiny is happening in the United Kingdom, and we can see it reflected in the advisory opinion of the International Court of Justice when making reference to the NDCs. NDCs are an obligation for contracting parties, but it's an obligation of best efforts. It's not an obligation to achieve the results, to achieve the emission reduction that have been communicated to the UN Secretariat. It's an obligation to put in place a system of laws, of legislation, administrative procedures, enforcement mechanisms to make sure that the country is aligned with its obligations to adopt an NDC under the Paris Agreement. But then my question is, can be as simple as changing the National Climate Change Act for the target to reach net zero. It happened in Scotland, it can happen in other countries. Then I will mention to the case in the Netherlands, the Shell case, where an NGO wanted to impose a concrete obligations to reduce emissions on the major oil company Shell. A district court imposed this obligation, not only an obligation to reduce emissions, but a specific percentage, 45% emissions by 2030 compared to 2019. And then Shell brought the case to the High Court, to the Court of Appeal, that issued a judgment in November 24, so less than 1 year ago. The Court of Appeal in the Netherlands said that there is an obligation for companies like Shell to take action and to cut emissions. But the court did not agree with the district court that there was a specific percentage to be imposed on the company. So here, what an innovation compared to the International Court of Justice is that the obligation to respect human rights by imposing an obligation to a private company is an obligation imposed on a private company, not on a state. It's easier to impose an obligation on a state to respect human rights, because this is the purpose of the states, to respect human rights. But what about the indirect effect? So can a private person expect or sue another person, a legal entity, for breaching human rights obligations? So that was recognized, and the Dutch civil law and an unwritten provision of due care, social due care, or due diligence that can be imposed on private companies. So that's what said the Court of Appeal in The Hague, but said this obligation cannot go that far to impose a concrete obligation of emissions reduction. The Court of Appeal said, we can see that Shell is taking action to reduce emissions scope 1, scope 2, and even scope 3, but we cannot impose a concrete obligation. So that's another limitation. And finally, there was a case also decided very recently in May this year, where a Peruvian farmer was suing a German company, RWE, in Germany, because the impact of burning gas in Peru was contributing to climate change. Then the mountain glaciers could melt, and the water, the floodings resulting from the melting would damage the property of this farmer. So the farmer was asking for compensation against this energy operator because of the contribution to the climate change. So there is a causal link, a direct and certain causal nexus to be established between the climate change, the climate event caused by climate change, and then the damage. In this case, the court in Germany said that the risk of the damage of the property could not be proved, could not be established, so the case was dismissed. But the court said that there was a legal obligation. It could be a responsibility for the private company if a sufficient direct and certain causal nexus could be established. This is something that the International Court of Justice is imposing on countries, on states, and we can see in this case that the National Court is imposing this casualty nexus and obligation on private operators. So to conclude, we can see that in these countries, Germany, Norway, Netherlands, and United Kingdom, there have been very innovative legal solutions regarding climate change affecting the energy transition. Other countries across the world can follow suit on the basis of the new advisory opinion of the International Court of Justice. But at the end of the day, this is a political process where countries are the owners of the process. The level of ambition is decided by states. The role of the International Court of Justice is to clarify the law, but the rules of the game are decided by countries. So it's a step in the right direction to fight climate change, but the court itself acknowledged its limitations, saying there is a role for international law, but there is a role for all areas of knowledge and social action, also for the economy and for the science, to all combine to holistically tackle climate change. And I think that fits. This is why that idea of interdisciplinarity is also at the heart of the CEPMLP in our programs, in our research, and in our teaching. So that's all. I think we still have some minutes.
Thank you both, Peter and Ernesto, for the excellent presentation and discussion. So we have a few more minutes for questions. Before I open the floor for questions, I have, again, forgive me as a non-lawyer, so just to look at this the opinion, and then Peter, in your presentation, you mentioned so in the failure of states to take appropriate action to protect the climate system from greenhouse gas emission, including through fossil fuel production and so on, like granting a fossil fuel exploration license will be a law, what's called internationally wrongful act. Does this mean that from now on, state cannot like oil and gas production, or cannot grant exploration license.
So that will prove to be one of the more controversial statements made by the court, as I said, when I outlined the findings of the court, that paragraph 427. But I believe it must be looked at in context, because the court premised the reference to fossil fuel licenses with the words failure of a state to take appropriate action to protect the climate change from greenhouse gas emissions. So I think the message is you cannot sit on your hands. You cannot do nothing. If you do nothing, then the granting of licenses, yes, may trigger a breach of international law that is attributable to the state. But I think it needs to be looked at in terms of what are states supposed to do? And that really is what this advisory opinion brings out very clearly. The time to act is now. You must act. You cannot say, look, I'm a sovereign state. I'm not going to act because it's within my sovereign rights not to sign up to treaties. There's more. It is a global climate law in that sense, and that customary international law, human rights law, it all comes in. There was a question about how to hold countries who are not party to the treaties accountable from one of the participants. In other words, how are the internationally wrongful acts dealt with? And what is the relationship of this with the principle of sovereignty? So states are sovereign. States cannot be made to defend themselves before international courts and tribunals. That's a limitation. And it's a function of sovereignty. So unless there's a treaty that provides for consent to jurisdiction of an international court, we could not have a case adjudicated by an international court, including the ICJ. But these statements in this advisory opinion are very authoritative, and I think that's where they will play out in a national setting, where private citizens may actually sue their governments and the shells of this world to challenge them based on what the International Court of Justice has laid out as being the applicable law on the international level. And that's very important and relevant because, for instance, the case that Ernesto referred to in the Dutch District Court, the court there also relied on international law to basically back up its finding under national law. But if it had the benefit of this advisory opinion, it would have been on much stronger ground.
Great. So I guess from what I heard, it sounds like in the foreseeable future there probably will be more law cases, so the lawyers can make more money, I guess. I wish I was a lawyer. So I guess so. Any one sentence final remarks do you want to give Peter and Ernesto? Maybe I invite Ernesto as just 1 minute to one sentence to wrap up.
So I would say the circle is round. We had treaties by states, we had statements made by the General Assembly of the United Nations, and now we have an authoritative statement on global climate change law by the International Court of Justice, a judicial pronouncement.
Good, thank you. Ernesto? Yeah, mute.
Sorry. I will finish with a more provocative comment. I think there is a backlash about climate change. It's becoming one of the on top of the agenda on the national political debate. I'm thinking in particular in the United Kingdom, where the parties in the opposition are using climate change to challenge the government decisions in this area, and is having an effect also on the government commitment or determination to tackle climate change. And what is happening in the UK will be happening in other countries. So there is progress, but at the same time there are big challenges And even if there are evidence of climate change and the natural disasters caused by climate change, floodings, wildfires, and in a way that are very concerning, it seems that other priorities, competitiveness, economic development, and security issues are for the time being a priority at the level of climate change as it was a couple of years ago. Yeah, so it's a very, there are competing policy priorities that make unclear what will be the holistic response to climate change. So there is progress within an area of law, but this is a small area of the entire response to climate change.
Great, thank you. Because of the time, I think there is one more question that comes in. I will just extend another 2 minutes, so maybe I'll let Peter to answer this question. The question is, the court says that states have a legal obligation to exercise due diligence under treaty and customary law, and the separate declaration of George Cleveland may that investment agreements lead to regulatory chill and their interpretation should be done in light of states' obligation. To what extent does this influence or would influence ISDS tribunals' interpretation of BITs?
So I think it remains to be seen how both national courts and international tribunals, including investment state tribunals, will deal with this advisory opinion, right, in their individual cases. The ICJ did not have parties before it, and it made it very clear. So these are very general statements. And I think that's something, a limitation that we must keep in mind. So query how directly relevant some of these statements are in specific disputes between two particular parties, be it an investor and a host state, or two states. So I think the jury's still out of how influential this advisory opinion will be. But really, right now, it's all we've got, in addition to, of course, the advisory opinion of the International Tribunal for the Law of the Sea and the Inter-American Court of Human Rights. So I think a case law, an international case law, is slowly building. And to that extent, it will have some influence on the issues that will come up in another context, not interstate, but for instance, investor state.
Okay, great. Thank you. Thank you very much, Peter and Ernesto, for the excellent discussion. As someone ignorant about law, I learned something. And thank you for the audience for taking our part. And today's webinar is recorded, and we will find a way to share it, probably on the LinkedIn or on the emails that you have registered. Many other participants are probably alumni. So if anything for the future you want to hear, we organize more topical issues to discuss, please get in touch. Thank you. Have a good night or good afternoon. Thank you. Bye.
Thank you.